and then ye should be in pay below better no. As you mean, ya china to move. Yes, me magic bill mano. Police for this bill no, me met ya say. Oh, that's it. Na mami fonika asi me ba no da ho de mu ye meli no na ye koji bill amano so ya mano sam komo bill na ye ka no cancel ye ka bill de adia de ani bill
yo kwesi me da se
yeah
say ye ka bill na aya na bebre no in chirase no edoso
okay
but send a metrias yama etiefo nyina beti ase preko pen say yes bill no a contract.
Okay,
it's a contract between the accused person, any or more whether guarantors or sureties, that's how we call them, and the state. Actually say abribia ye hear nipa no obetimi aba abegina atembu ano. What do I say?
Yeah.
And you know that is the definition I want to give to bill. Send a better. And you know wa ya bo kwedu no. Bill no be ye anyonkofa eda woni oman no entem. Anyone a ogina awachi entem evi so ochina bi wa ama omo ogina awachi no ye be come so.
Okay.
And it is like a binding contract.
Yeah, dear dancer say asem wo woni o man intem na mu sisi ani eja o kakra. Okay.
Because it's based on no the liberty of a person and those things which the constitution enshrines and the presumption of innocence. That is why bail is given.
Okay. What can courts need there no? I don't know if explanation I demand if that was in the context of court. Don't say police for so me my bill.
Yeah, it is there. So and also no. Yeah, back and also.
Oh, okay.
So that will fall under the types of bill that we have.
Okay. Okay. And nanka mi bisa say bill no. Obi right or under the constitution no nipa rights and I say the other way be I said a privilege and but what can say your types and the mention types and answer ya by no so say yes ye mu bi bela nipa right or what and I say a privilege a constitution no e dey amano which of these but my mention types no since I who say court need me my bill na police force to me my bill no e bia na apart from court ni police there no e bia me nim na foforo bi kra ho a now there no na so there my answer na yaba as to whether a right or not privilege no.
Oh, okay. So yes, as you say, we have the police inquiry bill.
Okay.
Bill na kasa no e won theory. But as and when we are going, yeah, better no.
Okay.
Until yeah, police inquiry bill.
Yeah.
So funny say asem no esi ye no. You report to a police station. Formally no nipa no ye to na no ye investigation. At that level no, police for betting I'm on the bill.
Okay.
Because they are still investigating. But as a bill no, it trim. Emra ye benya kwadu de abo onipa no na ye de no akọ court. Ye nya de ne dru court that bill no easy. It lapse oboni beka say it lapse ne bre
etwem na say the police di we ma no ye nya de wure mu o court nkwan de police de no eni ahon eni to me bio. Okay na say no say woni court ne na edi.
Very good.
Okay.
And that is the police inquiry bill.
Okay.
And I no CID no yeah, so at the station police station honum and on by e honum so no etimi ma o de nipa ba e mo begina wachi. That is what they call the surety. Surety no yes say ye gina ho say ko ba se mri bia mu hia nipa na se mo hu na ye de ne beba.
Council on police there no mpe bebre obete ebusuafo ni bi nkanom say o police for ni say bill no ye metu ase e ho ni kire mu police inquiry bill no ye tu ahun sika
kwasi ne ho ne say be into eska.
Okay.
Nanso ye de tabuo bi eto so. Enti police station won so betimi de tabuo ato so. Eno no na ebe so mu. Se na ebe ya unwane no. Enti se koba se udwane a na ye hwehwe na ye hu a. Obi o unwane ye kra so be hwehwe na hu no. Na nia omo a ombegina wachi sureties no. They will have to produce that amount. It is a tabuo na edu tu tisuno. It is only when the person is unable to come and stand trial, then the people who stood as sureties will be called upon to make that payment.
But counsel, you say be a full license na call as I say be man. But better so be all say ye ko bail no utia scam police.
Enya mi wanwa. Nanso higher kwan ho. But me am pesa me chiro ne say bill no ye ntua sika.
Okay. Enti counsel my enyewe say yeva ni say obi edemu ana obi ebusuani eda police cells na ye man police inquiry bill na police for ka say o metue sika na o ka say o ntua o mu mra so
eni mra bia mu say so tue sika bia.
Okay. Ebusuani na wate no but anke be counsel me did say we no me carry me inform say anke be ye say wo ko police station only mra nim ni beko.
Meka o baby. Na ya mre bebre no aya ye fa ni say oh we ye den. The last time a client back I'm friend or gala we here.
Okay.
Quickly and of free timene lawyer back on your call. Only sanke yankwanke de need I said it on my page, say, when you are invited by a law enforcement agency, whether the police or any other, it is not an invitation for breakfast. It is not an invitation for party. It is for serious business.
Yeah.
Ebeti mia and no lawyer anko. I am maybe nipa felice sikasem no. Nanso say all the rights to say sikana obepe de amano no. Ebi no mo okra all news ka ne lorry fare or the koja and those because emrano ka na yen entity any kire yen say eto ye be say we ye service free emma nipa o mu ni bi ye friend pro bono yen hyehyɛ ye no ne yen kire no.
Oh na o kira pro bono na wo mrem say at some point in time was say utimi ye pro bono as a lawyer.
Yes,
oh,
you have
okay.
to do it.
Okay.
You have to do it because you are living among people. Enye omu nyina na omu benya sika esese editu ya oka. Yete asese lawyer adwuma no enna form school kon kura enye yi books abeto enye we nanso so beka bible mu yesi maami bi da bia okọ judge bi ho o se wani na asema no a onya no edu ba bi se odi na asema yenti ase se enye nipa ni nyina ena omo ena do yemra no tembia enhyehyɛ da ho te se bia ba consultation enhyehyɛ da ho ebi 1000 ebi 1500 ebi 2000 ba sa ukọ oye nipa te se wa na ka so oh lo ye munye ampa 2000 ba menya 1000 ama mi nyi ni se obe ka se fa wa asem ko ba ya na de ase trim se ne bo edin we dey make kan twemu last obi fra mi fi asaman kese wa saase eye free wonsem ena me kire se ne ayen dey agise we dey oba office also mo consultation and I'm saying to the consultation you have say 2000 1500 o dey be compare wa saase a free wonsem na sometimes me enhwe enfaso na ubenya no dan ne awutua no so what am I say no that is it no yam fan says guys same be anim.
Okay, counsel, that's it. That is the bit about a year police inquiry bill, no. enti yenko court de nim wache police inquiry bill no ne nema kakra wo ho court de no so na
court de no so mienu.
Okay.
Yeah, well, bill pending trial.
Ye ansana ye bebe hwe wasem no.
That police for any charge against you. Normal they will go to court anymore. If it's Adam na trial has commenced. And when your man produce this and ni na trial. Sabre ni mu nyina kositama ye be convict ni a sentence no. Who are kwenya say ye be ma bail. And that is pending trial.
Okay. And a bail pending trial.
And then also court on kwan a bit me the amount.
Okay.
The second one bail pending appeal. The event is say I got that day there tremble. Time I sentencing we in the courtroom. Now all your appeal no. Yet me my bail.
Okay.
But sa bail no ding so benya.
Say do I call to
ya convict to we no. Nenti ding say you convict to we that presumption of innocence na ni hobiem. But that bill pending trial no there. We are saying per the Constitution, Article 19(2)(c), presumption of innocence. So uchi obi a eno nkyere say waye.
Okay.
Yeah, system no. Let me also make this education. There are two systems. We have the common law system and the civil law system.
Okay.
The common law system they say when somebody is arrested for committing a crime or an offense, the onus lies on prosecution to prove the guilt of the person beyond reasonable doubt.
Because all now so why?
Very good. But when you go to the civil law, when you are caught, it is you who has to prove your case beyond reasonable doubt that oh yeah. And yes, I will come. And to ever say, oh, no, yeah, chiwa uko prison into chuchajo. But here, there no, ochina, ona also watching. Into be at the corner also why no, Fabra, so we no bona no uko prison.
Okay.
Into that is the system. Into here no, yes, so uchi obia, the person is innocent until proven guilty.
Okay.
And because of that presumption, into no, the person has that bail right, and it is a right because it is enshrined in the Constitution.
Oh, okay.
So for Constitution now, you baby in the line say bail must be given to a person, but when you take certain provisions of the Constitution,
okay.
When you look at Article 14(1), that is where the personal liberty comes in. Until Article 14(1) talks about personal liberty, that a person has that liberty to move. Or wakwenya so benantina and say you're infringing on that liberty to move freely.
Okay.
But that liberty has an exception, and the exception is when that liberty has been curtailed, and it can be curtailed by the court or by law.
Enti court bill no na aka ye ode de ma ansa na ebedi asem ene ne ebra yenvan say prosecution omo de charge abo no
na court akodina amra nanim na ye do mra kobra monko tena ne yi 2 weeks time momra mobile ye we sa amra ni nyina no lawyer ni betimi agina na wa apply for bail.
Okay. Wom say ya te say say Ghana ne ewo no be bibia mamenka ni sa whatever being the case no yetimi ma bail. I don't know if that is true, but sadly was say emfa ho ni say dia wasem tie say yes nipa kum kra eno no kra say nipa kra na kum na lawyer ni timi edi bail kotum enti sa bail pending trial no. Is it in Chemu BBM? Is it in all cases? And court ne betimi ama osa bail no. and in all circumstances court etimi ema osa bail no pending trial ni dey na making.
Yes, all offences as at now are bailable, subject to the discretion of the court or the judge.
Okay. Enti judge no behwe say mehwe wasem ya ewom say constitution ne ka say yetimi ema bail, but based on 1 2 3 factors ye betimi ama ana ye meetimi ema bail no.
Very good, sir. Pepe. Enti no say ye besua ade kakra wo ho a eba bill asem wo Ghana, it has gone through evolution,
okay,
and sakraya bem from the past decade. Na say ye ka say your category of offenses be wo ho a say ba the court or the judge is prohibited from granting bail.
Oh, okay. Let's set it no nanka inema bi wo ho a judge wontimi my bail.
Say a banner say a falls within that category of offense now. The court is prohibited strongly into otie kura wie kura na say anka say otimi ma bail kura. It was prohibited, and it is the Constitution and statute. The statute is the Criminal and Other Offences Act 1960 at 30. When you look at section 96, a honor bail who sends them. But when you go to 96.7, and no na yen Papa Martin Pebu de court ye ka say no all offenses are bailable.
Okay.
But before that, there were categories of offenses, and I will try and briefly say main
okay.
Those category of offenses which were
not bailable.
Yes.
Okay.
Murder, defilement, rape, treason, narcotics. These are examples. Into section 7 now of a subsection 7 of section 96 of Atetia. That is where they have categorized that category of offenses. So for say the court is prohibited from granting bail.
Okay. But say in such a na bani there, judge no never share assembly, regardless of say murder, say defilement, say rape, and now judge never share said there a home and some kind no I just say oh as me say I no bentin meet me memo bill and I memo.
Very good.
Oh, okay.
Now nini na koba say section 96.7 which is a an enactment made by Parliament cannot override the Constitution.
Okay.
Ghana Constitution is the supreme.
Yeah.
And mean koba say ye be hihye mra bi na sa mra no be wotu mi or Constitution so. And where the offenses were not bailable, it means that act or enactment was suppressing Article 14 and Article 19, which says that a person has a personal liberty, which says that 19 says that presumption of innocence. Intimi koba se obeka se nipa no ntimi enconvict no adenti na ase waye enti it is presumed say or innocent, and this was the argument then the court has to strike down or strike out that provision in 96.7. Then now all offenses are bailable but subject to the discretion of the court.
Okay. Counsel, my yan share bibi so ewo honum. Oh, ze waka say yewo bail pending trial and na yewo bail pending appeal. Enti yenva ni say ebra a prosecution enya charge the ball no. Ye de wakotum ebia o lawyers na o manim for no am pre bail ama. Na emu ye de wakotum say be asem die no ekoso. During trial no and also it me a pre-bill the man a judge it me ma bill say o envan say o lawyers in the betuma judge it me ma bill a bra trial na ashase no.
Oh yes.
Okay.
You can apply for bail anytime.
Okay.
Depending on the circumstances. Obi owa ebia your boy ne kwa do police for the niko general court no kra. Only lawyer.
Okay.
And at that time no one be pre-bail na ma.
Yeah.
Into no that is where the remand will come in. Into then the remand also is in two form. Either you are remanded to the police or you are being remanded to the prison. So a remand will be and just say a convicted no. What I say?
Yeah.
Na say nipa ntimi nya bill into the police for mo hwe ne so mayen. Prison for mo hwe ne so mayen. Tem bia ye be friend asem na mo de naba. It doesn't mean that person has been convicted. So me omo ye de omo prison for no kra no. Untimi for mo mfra omo ya convicted omo. You have to segregate them. As I saw more baby or more. As omo no ye convicted omo.
Okay. In your explanation, okay, a year Martin Pebu versus the Attorney General. Yes, sir. Case no. A dear Nababe ye to bill in Ghana. A year Martin Pebu versus the Attorney General reference say or no dear Sam Koyama and ne. Ababe say all cases are bailable. Let's look at the significance of that case in general. A dear pan Ababe ye. Obeka say abeboa and I don't want to me person make your answer with me fako. Obeka say DNA no abeyama bill Ghana.
Oh, abeboa.
Okay.
Abeboa and oh yeah so many into your number 1, number 2, number 3, number 4 no na ntimi ama abontin. And number 1 no I think say it deals with disclosures.
Okay.
Now first no police for a kwawa. Bon say nema no bi on be ateta na uja kota na de abechiro why we but say no say ye di case baby a person use against me no as say o ma men saka na say me sumi wa no ye bi a me ya no ansa na ya courtroom ho entino say disclosures aba. Number 2 no and it was talking about all offenses are bailable. Number 3 no is also talking about the 48-hour rule. Which is also in the Constitution. I think 14.3 talks about it. So when a person is arrested, the person must be put before a court within 48 hours. And you know that Martin Peru number 3 no is talking about say even that 48 hours weekend is part.
Okay.
And I cast a maybe no unhia lawyer no. Eto de bia na your baba arrested or bet train if you are then in Rene Abecho.
Yeah,
very good. That is all bet them. Memen that kwesiada. Court ne say memen that ne kwesiada e kan 48 no. Ti so chini pa ni fiada kwesiada. Say when me anya court bia fana nkwa. You have to release the person conditionally or unconditionally. But up to now, Samran omubuso. Enti no SSO utwi ben lawyer.
Okay.
Na yet me take you on one. As you say, untimi mfam ransha won semenya ni ape. So betia ye nyu abutreka. So take you on Attorney General ni there because they infringe on his rights.
Okay.
The fact that the person has caused or has while breaking law no, it doesn't mean say the right no must be curtailed. We have said say the person is presumed innocent until proven what guilty.
Okay.
And to know to mention him baby more than 48 hours. That person will need a lawyer. Not to me because that one infringes on the person's human rights. So that is that. Into no 48 hours now or no. It cuts across weekend. Even court no can say holidays crack and
account.
So number 2 name fast run now and Abeka say na ma all offenses have become bailable. But charge no no behwe. Enti se minim se yan fa no so enchire no to aso so that enti no no what we are saying is
the discretion of the judge and say obema bill and no be refusing no has now. Okay.
Very good.
Okay.
there was a case which we call the Goldman case.
Okay.
It was between Goldman and the Republic.
Okay.
And the Supreme Court, it make certain provisions. Say, answer now. Say judge, as a bail abeto when say obema, say obe refuse. You have to look at these circumstances. And the judge is going to look at these circumstances, whether the person can fulfill these circumstances.
Yes, yɛde nhyehyɛdeɛ bi ɛbɛtoto ho.
Very good.
Sɛ utimi edi saa nhyehyɛeɛ no so a. Okay.
And that is where that discretion is coming from. Though we are saying that all offenses are bailable.
Yeah.
It must be at the discretion. As I say, you hear the partner with Timiba. And in that Goldman case, a whole Supreme Court, and give you that indications and these circumstances. Say, Nipano, a bit more for Phyllis and way there, then the person is right to. And if I should state them.
Now, in Tinamitoasia, say the discretion of the judge, and I say, you're right, say you bet me ama bill, regardless of offense, me to me, say, me bro, family baking, and yet absolute conditions ever home.
Very good.
Okay.
Very good.
You're right.
Because despite the fact say it is your fundamental human right, it must be juxtaposed with the person's ability to face the law.
Okay.
And you say, I am right, say minya bill. You're right. But you miss us say, yeah, this are right in the mawa. Really, Uber be jina and run anyone now.
Is that the only situation? You ever say bia? Judge in the best review so to say, bia, ni pay your money baila. You ever all kind of defilements in rape. At that point, bia no be who ni pani dance ni. Ye jana na your money baila. Obeti mi ako corrupt bia your evidence and I say, obeti mi abedi dance, obeti mi ako hunhunu ni na oko biwa. Judge, some I don't know if that is part of the conditions in any idea.
That is what I am coming to. And as you have said, it is one of the conditions that the judge will have to ascertain. And the first one was the nature of the accusation. When we talk about the nature, we are talking about the seriousness of the offense.
But Nina Wedin, he said the mood.
Okay. Judge will consider. And in asking for bail, you state the kind of offense. Into sa bail motion than any obey sa na mani na. Near tosumienu nature of the evidence. Someone say kwadu police for the kwadu bebo. Ansa na edwa kojina.
Yeah.
Eto be akwadu e de bebo nipa no. Who say emu oha. Enti se mu ye ha. I think say in the discretion of the judge, enyen ne den say obema say nipa ni bill. If you say kwadu na ade abono no kra no emu oha. Likely say you be wie kra no. You be jan. And yes say o see you be jan, but the likelihood say you be there asem na wie no.
I say asem na mu nye du.
Very good. Ade ba ko they say your court does not deal with spiritism. Into the kwadu abo be say obi the beye ekun onua. You see the charge.
Yeah.
Emu ye ha. The evidence is weak.
So
because very good. At the end of the day, you be the likelihood say you will not succeed is high. And in this one is also a factor that will inform the judge discretion.
Okay.
Near to should be a severity of punishment. I offense now I know a so tree. Now so tree no a kitwa and answer a wa will attract a long sentence or a short sentence.
Okay.
If it is a short sentence, then it means such a person me man the bill la thing be obeba because it be offense or a misdemeanor that for very types of offenses no say be a misdemeanor and no crime no say you're convicting sentence and it can be a fine.
Okay.
In this any power way no say me man bill and he fine no beko. But be a offense yi ubetimi ajibe say 50 years. Say any power who say yeah man bill na say we dey say me we na metimi adam 50 years there. And I say obetimi dey no okay right. And also be inform the judge what discretion.
Okay.
Now what can ba nso ye flight risks. So I'm move be motion. Obo say lawyer never say my lord my client is not a flight risk. Oni obi obedwane. Onyane. Emre bebre no. Say nipa no wo ba bi te. And these are some of the things that the lawyer has to convince the court or the judge. Nipa no office place of abode. He lives in the community obi animu no. Enti ebeye den na say ye man be ojane. Ba ye kan onipa ye hu no community mu hada. Obi aponchi bi no be fae. Na ye chi no. Musu ye man be ahin fa no oko. Wo su okra unim ne wahi. So it has enti no the judge will look into it. Does the person have a fixed place of abode? Ya hwehwe na ni fie ni aha no ote.
Enti ero na etoda obeti yesu police for kwhwe baby anipa ne te.
Very good.
Ni ade e bia ye be sureties ni so but etimi ebetimi so aba say omo mu gina na echi ni ye be kwa kwhwe omo su fie ni omo ejapade omo.
Very good.
Oh, okay.
Until home say na aka na ye be ba ho.
Okay.
The next condition obesan hwe biem interference with witnesses and your client. Afi na ya ba ho. Sometimes be a nipa no a prominent person. Your money bill no occur society na either he will tamper with witnesses or evidence. The witness any akan no ma assembly see they were around into no eto na edian say any pen e be from say mo medi adanse. The person may go and threaten them. Interfere no kra no say police work from abakra abakona say fumu omo tu kwan. Oh, me nebiem obey ne den. And they will look at all these circumstances. Say nipa no ye jana is the person going to interfere with witnesses 1, 2 evidence. And near man investigation na ye no. Obekwa ko temper with data na because he is influential. Obetimi akwa ye bibi ama ade no kura beba bedu court no na
and that's na pen na say
and said that ni mu ana and the judge ne be hwe no so. And the last one is repetition. Is it likely that say you granted bail ma akoya okwa obetimi asan akoya bone foforo ana offense foforo ana?
Okay.
Ebia ya fa ne say nipa o de second na wo bi sebi na omo mjeje anche nipa mienu bi hu ye e na say nipa eso kra na police for betchin me na makwa report no ntwen me kwa ba mo bi hu
abontre ni ato okra inside the vehicle.
Into the likelihood so okwa say nipa no obetimi akoyo bibi kra ho. Into the court will look at it say if you look at the circumstances say ye je nipa ya no okwa obetimi akosan koye bone foforo na
obi timi ka say o de ase mu ko reporter ne bompa say me kwa mi wu enda cells ho na be fie dia.
And such a person no, if it is evidence and as a police betchu na o kan say same way na so am they can charge sheet no and I say in your statement I betchu no ni nyina pp o mu a then say koba say who pay bill sa na ma we nyina da judge nanim obi a wo threaten crofo no yenja wo neko. So these are the factors that the Supreme Court brought out in the case of Goldman versus the Republic.
Okay.
And in say how can we ni niema judge ne be hwe and son wa granted bail.
Okay, into the edikan born na we said the mudu esiti.
Yes, the nature, how serious the offenses.
Adansidia ewo de waye no
nature of the evidence, and whether it is strong or weak.
Say ukufia ade ni say obetimi akoye bi ma na wonkoye bi
repetition.
And na say bia ukufia adansidie ya ewa asem no ho say wonko say na say wonkonya nsunsuanso bi ewo so.
Very good.
And say si ja na si yepe wa ebenya wa na ye nya sa ne menum mintu say 5 na say bia meje bi o ma.
So last one is severity of punishment.
Asotwe
na ho asotwe no say one na say ntino the listed 6 conditions the judge will consider.
Okay. Enti yembra sureties no so. Obeti say nipa simesi bill na ebia court no edema na judge no edema no with 2 sureties, with 3 sureties na bia ya boska bi say ho ni kire mu sureties ni ye de ya na saska na ye bete say ye de ato be say na say we de nipa yi or confess saska no ehin ni ade no, especially o share some of the, I don't mean to say saying political prosecution be say that is, I don't know if I can use that term here. Obviously say na nipa simesi na buy na ye ni we chance na hwe bill amode ato no so na 50 million there. Na say yati be 50 million, be 200 ni ade. Saska na ya ebodi ni obviously yes with 2 sureties no. E ho ni kire mu ase kire pan ni say.
Okay. So will come under the bail conditions. Okay. My main take it as a whole, then I will be specific with yours. So before or when granting bail, the court imposes conditions to cause the accused person to return to court. And those are what we are calling the bail conditions. The bail conditions are in different forms. The first one, self-recognizant bail. Eto de bia obehu se nipa bi ni dibia ni nipa ban ni titru a oyenti no. Se bia asem bi ba yetimi ehwe nipa we. Ye ma sureties bia emma.
Okay.
And ya no na friend self-recognizant bail. Esan nipa we dey onwane. So what I say, nipa titru a owo community ni. And e bia asem either say ye no kra ye nya dey aboard there, they will prove.
Yeah.
And say nipa no yetimi. Say nipa no so no ye de tabo bi eto ho say ko ba se went me ama court ni bi ma. Ubetua. And even though it is self-recognizance, no, yeah, the bond eto so. That one we call bail bond. Sa sika na ye bon answer na obema no emre bebre no ye hwe the value of the offense that you have committed. Sometimes it is a discretion. Yeah, to be half of ebia yes where the money way will be car ne value 1 million Ghana cedis. The judge can give you a big bond of let's say 500,000.
Yeah, no. Wo na wo ye self-recognized bill no betua otai scanner to.
Oh, says scanner untua.
Oh, okay.
But you must show proof.
Say was that scanner.
May they bow sureties no so no. But the first one is a self-recognized. Yeah. About sureties now.
Cancer mintua no. Enti self-recognized bill no. E betimi aka say oh yes surety di ama wo
sir.
Say ye better say in simple terms.
I don't know udibia ntinu unhia obi foforo say o mejina wachi.
Okay. Okay.
Unhia obi foforo bia ma ni mejina wachi.
Yeah.
Wow, it is unyi obi abedwan yenimo. Nipa we o ejapade bebre wa ha. Be then asem ketua we obedwan. Nti ye hwe ni dibia no so ne ama no.
Okay.
Second one is sureties no. The sureties are in simple terms they are guarantors.
Okay.
That I say. But in the court parlance, any from say they are sureties. Omujume di say. Omujume di say. Omu jina aka che court to say. Emre bi say wo accused person na ye ma obe no esese obe gina emra nanim no obeba na se ko base nipa na ya bo ne kwadu no kra no edwane a ye be gina na be born tabo na ye de ato ne so no mo maji wo ye ho
na say omudi akagine mu awan.
Very good. Say sika no ye nyinto ho but court need to make us say justify. You can say maybe 2 sureties. Simplicity. Not just say you just have to come. Oh, yemi enuni. Mostly almost say for Ghana card the church or Ghana ni. And to almost the bar, they prove say there are 2 sureties. That is all. But so some they come say with justification there. Nature says sureties no. As I saw me be chere court no say omo edwapade. And now say sika futu obi. That is the justification.
Okay.
And you know, it all will depend on the intensity of the offense, the type of offense. And you know, says they are sure it into say they can they are near the 50,000 Ghana cedis opportunity. So, if you have 50,000, because say oh with 2 sureties, simplicity, or with 2 sureties, justification.
Okay.
Say justification ni bem dia na say omo cover document ba e kire say me wo edan we wa I have this property, so document covering the property. Or your bank account wa ko je aba oh me wo sika say e da me bank account no I don't know the court will want to see that evidence before they can grant bail. The surety no one say
enti say nipa ni begina as surety na sika na yabodin no oni japade ya ebedru sa scan na oni sa scan eda na account mu a na say o say o copy be foforo.
Exactly.
Okay.
Exactly.
Ma yente Facebook message we obi say hi Kwesi, good morning, kindly ask the lawyer if the money paid for bail term is refundable if the accused or suspect reports after being granted a bail. I don't know say no more or less when things the way you and say no na nyeska you to ho.
No, I this odwane a and e hwe ne ehu na na mba betua say sika no. Esha nine.
And in this case you hwe no question na say nipa no edwane na omo betua say sika no na echire ye kohunu na de ne ba.
Oh, I believe say the court will refund.
Oh, okay.
I do not think say ye person nipa na obegina emrana no na say
yes akana
say ye Jesus ka na emra ye nya nipa ni biem ye hu no obi wo ha ye man ni be na puwa wa fa ne bag
ode no ha kenwira. Okay, but go say the way free Janeta no but say who is a suspect. You know say you have to clear no mind quickly now. Yeah, so I say who is a suspect in the question on that one.
Oh, okay, so Obiara Obiara in the mind of an enforcement agency, let's say the police, in the mind of the police, you are likely to commit an offense, or you have committed an offense, or you are about to commit an offense. You will be a suspect.
Counsel say si so ba kuyo.
A suspect. So I'm say you are a suspect.
Yeah.
But say on am ho so na ugina ho na baby ugina is an all time all place. He can suspect you.
Okay.
That one you've not committed any crime. That's why I say you are about to.
Yes, a bonny bon ye hwe ni no mama so.
Okay. And one day we'll talk about that. The law gives them so much discretion.
Police force.
Yes. It's so much wide. So na mo keke kura na obey me because if you say you are about to and I say you will commit. And you know when somebody is a suspect, it can be say nipa na ya de no and I say onyo be ya de no and I say oba be ya de no.
Okay. And sister Janet o question no anu ye no nti suspect ne de enyu bi a police ache ne nkwa ye hwe enim no moma so ye hwe se de onante yi kwa akoyi boni abegina ne tim onya boni obedi a
ya me bebre no aya me catch re emabun ne se oh me hu se Shatawale atwa ne tirase na waye ne tim pense ewadwuma Shatawale ye oye nyuntini nti esese okọ with that brand also Kofi Antobam me ne wa na she get to ho ye she emfiche ha wakwa rewu tirase bi se BBC na even say police for enam normal picky suspect they will pick you simply because of your outlook.
Okay.
Entinu I told them be a lifestyle no your fan say oh ye hu TV so na ye bi but we don't know the implication.
We ni pro bono ni bi ni typical pro bono pa na dia ma e futu di uti o ye bebu oh Shatawale ye me Shatawale fan obi so ye me mentor enti de Shatawale ye bia me ye bi Shatawale obetimi ama no e ba ni bill a no obetimi ama no kra self recognized bill na also
very good
wa je u copy obi begina wechi na mo wa hwe wo namfofo ne webusuam so bi wo ho a e bia envan say the 50,000 Ghana cedis 2-3 say eno kra na e bill a obi webusuani mu wo hwe wo namfofo mo bi wo ho a obetimi abegina abedi akegini wa na obegina as surety e dia mo na nti na o de no e de tumfo make I also with time with the law our Freedom Radio 89.3 FM na ene yeni yene Dominic Uforiboedi Esquire ofri bako apem chambers ewo Kufori ha Senate building mu na obehu omu na ene yene no edi nkomo e de afa bill ho e de na Ghana emra no eka se ebra police ache o ebra ye de wakogina court ana se ya charge o ye de wakogina court na ya charge o no bill hu nsem no etisen na so far wa cheyen bill ne nkyira se ahodo awum eye police for de e na court de no so eye ahodo mi ne no so wa kire yen obeti yes sureties obeti yes bill conditions ni nyina ade a ode yen afemua de aba bedu baby a ye we enche ye bebie phone lines no e de amount na owo asemise bia wetimi e de aba but ye da ho e wo Facebook obetimi ajoin in live Freedom 89.3 radio na ode questions ne o comment ni nyina e de ja ho ba na wa like page no wa share link no so na foforo etimi akaye ho na ye di dwumedie no e de ato aso nti customer yen toa yen common so na at what point ni ebetimi aka say bail condition we there too harsh ana yetimi mpo kasa ana say ebia nipa enva say nipa na yedi ni accused person no ne lawyer say betimi aka say bail condition no ana betimi argue say bail condition we there no edin do.
Okay say ekoba say you guarantee bail ni ma near the conditions ne ka ho untimi nyina wo na mu hwa enka nche judge ne say too harsh and I say you cannot fulfill them. You have to go and try. Into ABI yama yes two sureties with justification. So what I say?
Yeah.
By yako chinya nipa enya omu nyina no. They cannot justify. Omu betimi aba abegyina ma no. Nanso omu ni adwapade bia esese omu na so omu betimi de ho document. Omu ni sikafutuo bi da ho a ombenya ho ombetimi akodi statement dia be kire sampa ye wo sa sika we se banisa lawyer no be san ko judge nanim with another application we call it motion o akosre judge ne say mira otembuafo we there yesrewa yekotudwe egu fom be na o de ma ye no ya besi na yentimi ye nti ama ye client ne kura ogusu ye den e wo police for ekukum isan say yenya omo mbegina nanso yentimi an justify nti yesrewa varimayen So I say everything you have to go back to. And before say baby a chichira boy no one is son no. Until say koba say a hash in your estimation. You don't just stay or stand somewhere and be saying it is harsh. Okay, is harsh, you know. Which sympathy are you? Sometimes maintenance about I say knowing the law, knowing the right channel, but still you will stand and make it so that in the minds of the public, you know, the judge will be seen as bad. Sometimes that's how I see it. We're making those reports, forgetting say it is not anybody that we are punishing or we are speaking against, but rather the one who gave us. Ono so ye na adwuma. Se koba se wanya no se ne be ya manipa na ba be gina emrana no na so odwane a. Ono so obi a or report to. The judge has somebody that he reports to.
Yeah.
Enti no ye be query no. Why did you do this? Do that? Enti na adwuma no aye within the law. Enti so ofele say oh ye call ye prayer enye ye san ko nanim. Oh ye nipa mesrao o my bill o the conditions kan na so ya yentimi yesrewa ye ko to jogu form gumu kakra mai obagum.
Okay, na ebetimi aba se ye de obi akogina mranim ne lawyers ebisa bill di amano ma judge na hwe conditions ya o kan yi wa hwe mu ma wa mani bill ne ma se die ni koso no na court na said the reckon of case no asanso revoke his bail condition no under what circumstances?
Very good. So say there are conditions. When you na say okay your first you way on rent anyway.
Yeah.
Because there are conditions and warranties.
Yeah.
Conditions goes to the root of the agreement.
Yeah.
And you know if he has given certain conditions and you break those conditions, you will revoke the bill.
Okay.
Ebi a me ma no me catch you say na what we be for an culture police for. Report yourself at the police station once every week, maybe Fridays. Now the next time you be back court no, say police for no lead evidence say for 1 month. And now it be 2 Fridays went to Myanmar, the judge can revoke the bill.
Okay.
And you know it will depend on the condition that you have breached. That's what I say.
Yeah.
My mao bill no, but we say too kwan.
Ebi a untu kwan free o man man, untu kwan enfi kro na.
Yeah, o man mu the most inquire o mojo o passport.
Okay.
The memo deposit to passport or registry.
Okay.
Say oh you foreigner now say you are likely to maybe go outside that. I remember say in one of my court attendance there was no there near content, but the day he has to come to court no Otukwan or Dubai. When the judge became aware of it, or issue bench warrant, say and find into such a person who feel Dubai will do airport I bet you. So what I say because you know say SSO yes I never until when you breach a condition of the bill, the judge will definitely revoke the bill.
Okay. And here we shall know how something na mpese e call back to police there no. On say what can say in Pebu versus the Attorney General also or about 4 cases and a year constitution ni mwankasa no. Actually say police actually suspect are within 48 hours. I was say ye no I was almost ne ekogina court na omo etimi e charge no. Then I can say your police inquiry bill. At what point Edna police within that 48 hours now I was here no acquire fanning coin na nipa ne bia ne lawyer for abana omo police inquiry bill there man police a bit may refuse say nipa ne e money bill wo bra ye mfa no kogina court and charge.
Yeah, so ni nyina so begina sa conditions ya ye keka ye wo go man case ni mu no say police ni so in their mind if they think say a bit in your course, so say your money, your investigation, your money bill no qua, or back temper with investigation, they can also refuse to grant bail.
Oh, na meto ase na to me na court no one some way somehow police no so ewo mu kakra. Oh, okay. Okay.
And you know, say nipa be interfere with evidence near here. Because sometimes when they arrest the person, they have to be doing background checkings and those things. And if they feel say all those background checkings, you know, your man inquiry bill no crowd no be interfere with that, they can also refuse. But their refusal has a limit. You have up to 48 hours. So it means that within 48 hours, you must be able to get all your evidence, your investigation. So for say within 48 hours, no unya ya. Emran say fa no court enim. Na court. Na court nema more time. But say one for na nkope, then you are breaching the constitution. Okay. Article 14(3). That 48 hours rule no. E ho na be ho.
Oh, sepa. Okay, can't say that. Messi and by the old year entire corporate building and no ho kwedu near the airball. Ebi a dinner first time no, second time na omuko bisa no. E dey no e be society a bi e be ma judge na hwe na sa bre no no wa ma bill.
So on say abribia me ka say the rule of the game is evidence. Ebi at your first application, there were certain facts that you were not privy to.
Okay.
Facts be na when ya akwenya sabre no. And in the first one no went me. But so refusal, you have to repeat. So the first chance is to repeat the application again.
Okay.
Before the same judge or a court of coordinate jurisdiction. Omoyepe titi say be a circuit court say o refuse circuit court metimi akọ circuit court or suhun no mako apply. But most in be adeni see that one is laudable.
Okay.
And it's a kobase who repeat it, no refusal, then you go on appeal.
Okay.
So you sorry and now ko appeal it. You refuse to be first you have to repeat the bail application and it can go before the same judge.
Okay.
There were certain facts that you were not privy to at the first instance. You can add those facts. In the first instance when to me and convince. So all that the lawyer you have to do is to convince the judge, the court, that Miratemua for say my client bail be obeba bejina emrana no. First why I no went to me and judge and they said my client no o fie wa ha o te ha o ni nyina nti me ama o we nim and o refuse ye. But after what be say say me nti me and ne say o te ya. Then you are going to repeat the application again. This time round those evidence that were not una unim ana urefi and you will now bring it. Oh, my client no some conditions now Supreme Court in Goldman's case you have to evidence all those things. So to me convince the judge and say my client can certify it into on your flight risk. He is a person of integrity. And the abono no and is and the sentence no and what's those things or fixed place of abode or people are more best and sureties or family members, they have properties and those things. You have to convince the court. But and no that's there, then you go on appeal. Okay. Maybe to the high court. Or if it's not the high court, you go to the court of appeal. Yeah,
appeal now. A bill no kwa appeal now. Kwa nye substantive case in a war a year court name. Oh, okay. And in that case, no kwa appeal a higher court than baby asem no. I want to say, share appeal no has bill no has no. I can we are substantive case in the judge in the one and him no one ever to ask no ready.
Yes. So okay. He is the trial judge or trial court. the bail application is, let's say, a subsidiary of the case, the main case.
And
yeah, that is not the substantive case because what offense they are born, by share liberty, personal liberty as enshrined in the constitution. Into now so what you move freely. Now your course will do assembly.
Council, your brother also. Yene lawyer Dominic Kufuribu Edia o free Bako Apem Chambers and no Elwo Kufuridu Senate building no emunene anope yene no edin koma or church ye bibi